Hey business owners and trademark applicants, let's talk about office actions and filing fees for trademarks. So in this series of Juneteenth inspired trademark applications, I'm going over very important lessons that you're going to want to remember. And this one hurts. This was an expensive lesson for this applicant. They spent over $1,700 just in filing fees alone for their trademark. If you don't currently follow me, I'm attorney LBJ. I'm an intellectual property lawyer who likes to help small businesses understand brand protection through hot topics like Juneteenth. So when you file a trademark, whether you do it yourself or you have the assistance of an attorney, one of the things you must do is identify the class of goods or services that your trademark will be registered in. For each class, there is a filing fee of $250 or $350 depending on how you file your application. And classes are extremely important, so you have to pick the right class. You don't want to pay for classes you don't need, and you also don't want to leave out important classes that properly identify your goods or services. So it appears that this applicant was trying to primarily protect t-shirts with Juneteenth, but they did it in a unique way. You see, they've used descriptions like textile fabrics, protective clothing, polymer base used in manufacturing certain goods. All of those things really sound to me like t-shirts in one way or another. But it is very possible that this company, in addition to having a retail clothing store or custom design for Juneteenth, also manufactures this unique type of polymer base that they sell to people under the brand name Juneteenth. Probably not though. But what happened to this registration? The pro se or unrepresented applicant got an office action that basically said what I knew it would say before I even read the office action. The United States Patent and Trademark Office rejected pretty much all of the classes of goods because it was too similar to other outstanding trademarks with the name Juneteenth. Now, I do comprehensive searches before you even get to the trademark stage. I could have told them that from the beginning, would have saved them a whole lot more money than $1,700. But this makes it worse. So through the office action, the United States Patent and Trademark Office didn't delete or deny all of the areas of goods. It actually allowed one of the areas of goods to go through. It appears the USPTO wanted to allow this applicant to register textile goods. So if you made fabrics that had Juneteenth printing on them under the brand name Juneteenth, and you sold those textile fabrics to other people who then manufactured it into other products, they may have been able to successfully practice and file that trademark. But they did like most pro se applicants do. The application looks pretty simple. But then you get back this very confusing office action, which is a legal memorandum from the United States Patent and Trademark Office that explains through case law and citations of law why they're not agreeing to this trademark. But most office actions get reversed. They just require an argument, legal argument. You see, the United States Patent and Trademark Office, they don't have court like you would normally have a case that you would litigate. Most of the correspondence is in writing between memorandums of the parties that go back and forth. So lots of lessons here. One, there's a cost associated with each class of goods that you attempt to register. So pick your classes of goods very carefully and don't waste money. Lesson 2, if you're going to DIY it and you get stuck on the office action, don't give up. You may be able to succeed. You can bring in an attorney at that time. Not all attorneys take it at that level. I do. But to be able to determine whether or not you can actually get this trademark through the process, you've already spent some money. And 3, don't forget that comprehensive search. For $350, I could have saved this person a whole lot of money because I would have been able to tell them right away which areas that they likely could and could not get a trademark in. The retail clothing store, the pants and apparel, I knew that was a no-go. If you learned something, give me a follow.